Attorney General said he recalled one in the past. And I believe the one he recalls is the one that had to do with the Road Traffic Amendment Act. That also included provisions with the likelihood of people going to jail. It was a private members act. It was assented to, and we didn't have these issues. And so, I'm urging the court to follow its previous decision where it laid it down that presumptively, the court will not injunct this process, which has not reached a point there's nothing dire in it, because the president may exercise his various options to get what their very issues that they are articulating before the court addressed. At the very best, they should submit it to the presidency. They should not let this court arrest by way of an injunction.
But Mr. Sory, I recall presiding over that matter. So yes, I can actually tell you what went into that decision, which is that the matter was still in Parliament.
Yes.
And whatever it is we were being asked to consider in relation to Article 108, it could be cured. It could be cured. Right now, you have completed your processes and you have a bill. Is it your submission that it can still be recalled for the purpose of curing this alleged omission?
Certainly, and that's exactly what I've been saying. So first of all, it is still in Parliament because by virtue of the pending process, the president has not accepted.
That's why they're saying that. That's why they're saying that we should use our power to keep it with you until you correct what you have done.
And secondly, I'm saying that the concerns they are raising.
Do you understand?
The concerns they are raising are matters they should send to the presidency. If it gets to the presidency, the constitutional provision that requires Parliament to mandatorily at this stage not be keeping it with Parliament, but to send it to him, allows him to take into consideration their proposals and send it back to Parliament for reconsideration, and Parliament can incorporate it.
I think
that is the constitutional.
I think the point my Lady Chief Justice is making is that they are alleging a grave violation of the Constitution, in the sense that something that ought to have been done before this bill was, as it were, completed, was not done. You understand? And they are asking this court, because of that, to take a decision and restrain Parliament from proceeding to perpetuate an act which constitutes a violation of the Constitution. You are saying that they should rather take it to the presidency for whatever remedies that they can obtain there. And my lady is asking you, what if it's a matter that constitutes a grave violation of the Constitution? What prevents us, as the apex court of the land, from taking the decision on it? That is the question we want you to address.
Very well. 3 answers. First of all, there has never been anything like, our constitutional history doesn't admit of anything of like an infinitesimal violation of the Constitution. Every violation of the Constitution is grave. 2, this is an alleged grave violation. They put the tag grave violation. I'm saying that
they put the tag novel.
Well, it refined to novel, and in many instances, if not in all instances, the matters that come here are novel, because if they were interpreted, we will not become accept Article 10185 or so. Was it 181 clause 5? It has come here a number of times, but the court has said that if this court has determined a matter before, don't come back here. It will be enforced by the lower court. So as for novel, grave, all of that, it is not a ground at all. It shouldn't even be canvassed in this court. As if to suggest that, some of them, we could just treat them with levity. I will get to the cases that he cited about, some involving the creation of new districts. What is happening at SAL? So there will always be these matters, and there will not be little. In any event, we say that nothing irreparable will happen if this court does not. What this court rather is invited to do is to do something that I don't think is constitutional, because it is a process that must be followed. And all of the things that they are urging on this court are capable of being decided and determined and catered for in that process as we speak. Why are they thinking, in fact, the key question that came from the bench, which still hasn't been answered, is why don't we trust, and the Constitution has given the power to do it, why don't we trust that the president will do it? Unless there's no such allegation too. So in every way, there's nothing new in this particular matter.
But the issue, Mr. Sory, the issue is, do you, your client, Parliament as an institution, if Parliament as an institution agrees with them that there is a missing vital link in the considerations they should have done, why should it allow this court and allow the executive and allow the country to be expending energy on this question? If you agree with them, correct your omission. If you don't agree with them and you insist that you have done all that needs to be done, then say so.
Oh,
but you can't present a vacillating position even if there is a gap, it can be fixed between the two institutions. Has there been a violation or hasn't there been a violation? If you agree there's a violation, can you go and fix your violation? If there hasn't been a violation, can you say so? So that there's a determination of that.
Very well, Malidi, I think that is the point where I lost you. The submission I made to this court is that there is no violation. And I read the rule saying that, does the bill make provision for? All I hear is that it is likely to have the following impact. Does it make provision for taxation? Or does it have a provision which says, in respect of this particular matter, it should be charged in the consolidated fund? It doesn't have any such provision. All they submit to this court is that there is a likelihood that that will happen. And I'm saying there is no such violation. Indeed, I have attached to my affidavit in opposition Parliament's reaction to the Attorney General's position. The current one, the prevailing one, filed on May 20th, 2024, Exhibit 3. And I've referred in my affidavit particularly to paragraph 7.13 at page 8. So all of his impact analysis issues he's talking about. Yes.
You are speaking about your affidavit in opposition of 20th May?
Yes, my lady.
It's made up of 7 pages.
No, my lady, there are exhibits.
Which exhibit?
There's exhibit 3.
Exhibit 3.
Yes, my lord has found it.
Yes, okay. Please go on.
Yes, so my lords realize that in paragraph 7.13, Parliament's committee notes that the committee wishes to indicate that the concerns of the Attorney General have been taken care of in the committee's proposed amendments. That is very clear. That all of the issues that the Attorney General said, oh, he advised them on, Parliament did. The court is referred also and the court is referred also to paragraph 8.2.
Short paragraph.
No,
the 3-line paragraph.
Well,
is what took care of the Attorney General's concerns. And
in that paragraph, it's a well-loaded paragraph. It says it is being. Oh wait, my lord. It says it attaches. My lord, look at Appendix A of it. They have listed all the various amendments, and actually in paragraph 8.2 also it says, in the light of the above constitutional imperatives, the committee decided to seek the opinion of the Attorney General and Minister of Justice on the bill. The Attorney General's concerns were duly considered. I think we should trust Parliament too. That this is a report coming from Parliament, that these concerns that are now relied on by the Attorney General.
I think I'm understanding you in this light. You are submitting that there has been a determination by the person presiding in these clauses.
First of all, yes. Secondly, their contention based on the clear tenor of the rule cannot be correct. Thirdly, all of these matters can still be taken care of in the legislative process.
This is where I come back to my position.
No.
Have one position.
No.
Have you contravened? If you have contravened, do you want to go and repair? And if you haven't contravened, say so that don't push us into writing. We start here. It's 12:30. If you haven't contravened, have a firm position on that.
Yes,
then we know what to do.
That is so. Mm-hmm. And there's a report from Parliament which confirms that. And they've not spoken about it.
Mr. Sory, I'm sorry, let me just ask. The Honorable Attorney General was talking about a process which is ascertainable.
Yes.
You understand? Yes. Now, what can you put before this court to satisfy us, to enable us ascertain whether the constitutional duty that was imposed on the person presiding had been duly complied with? What evidence do you have in your processes?
Exhibit 3 is clear.
Which one?
Exhibit 3, the one that I've just read to you, said that it's in reference directly to what the Attorney General put before Parliament. It says that.
But Mr. Sory.
Yes.
If you look at 7.1.3.
Yes, my lady.
The committee wishes to indicate that the concerns of the Attorney General have been taken care of in the committee's proposed amendment.
Yes, my lady.
If I have concerns and I convey them to you, should you say that you have taken care of them so I should be satisfied?
Very well.
Or I should be satisfied by what you have done, that my concerns have been addressed, in which case I will stop complaining.
Or you should show me what you have done, rather than tell me that you have done it.
My lady, between Parliament, which has the power to decide or to proceed in the manner in which it is proceeding, and which had no obligation to, even in terms of the legislative process, to seek the Attorney General's opinion. It sought the Attorney General's opinion and assured the Attorney General that, yes, I have satisfied the opposition. And that's the last point between the Attorney General and Parliament.
But respect.
But if you say you have satisfied the concerns of Attorney General, how?
In terms of their proposed amendments.
Mr. Sory,
Yes.
respectfully, this is the bone of contention here.
As I should.
Here, the applicant said you should have attached a fiscal impact analysis to the bill. Then the Attorney General said there should have been a determination even on record. And third, within the bill, there are clear provisions that require a charge on the consolidated fund. And there has been nothing attached to show how the mathematics, the money, the cedis and the dollars are going to be determined, and that this is the requirement. Is it your suggestion that the arithmetic is not a requirement?
It is, first of all, not a requirement. It will only be a requirement if, first of all, the bill, the Attorney General had got up and read part of the bill, which showed a charge on the consolidated fund. And I've made this argument so many times, that the reading of the rule does not require what the Attorney General and the plaintiff are saying. It says if the bill makes provision for. So it would have even been a point to consider if the Attorney General had read one part of the rule to say which of them imposes a charge on the consolidated fund, in order for us to even to go into a further interrogation of this matter.
We will wait for your submissions on that in the substantive action.
Very well. And my Lord, this court made that determination in the same application that came before this court, that it would rather abide the substantive hearing of the matter in order for us to go into to these issues. So that is the first point. And I'm saying, in any event, the legislative process doesn't end with the full and final debate. It still continues. Yes, because the bill could still come back to Parliament based on all of these arguments, brilliant arguments that have been made in this court. It could still come back to Parliament.